Recording in progress.
Good morning, Chairperson, and good morning, members.
Good morning.
Good morning, good morning.
Morning.
Chair. It's 9 o'clock. We do have the G in the meeting and Advocate Malakate and from Parliament Legal Service as well and the State Law Advisor. They are all in the meeting. We have about 7 members in the meeting, so we can start, Chair.
Okay, thank you very much, colleagues. Let me start by extending words of condolences to our colleague, Honorable Machi and the IFP, but also to all South Africans on the passing of our Member of Parliament, Honorable Sithole. As you know, all of us, that there was a terrible incident that led to his death. And also we extend to those that also have been affected, the two that are in hospital in terms of my earlier records. And we extend, must be strong on the family on behalf of the committee. I'm sure members when they interact, they will also extend the word of condolences. I'm not sure if we can a minute for a moment of silence.
Yeah.
Thank you. Welcome all honorable members. Welcome the Director General and your team, the Parliamentary Legal Services, and Chief State Law Advisor. We're going to deal with a few matters which will not take us longer in this meeting, and also adopt our previous minutes. You'll recall, members, that in our last committee meeting, we decided to shift the item which will deliberate more on item number 3 to last week Wednesday. And in our interaction, we then there was a consideration that there must be further consultation with the Director General on the subject matter that we will be highlighting after the apologies. And then after we will deal with the adoption of the previous minutes. And hence we have shifted the meeting last week to today to deal with these issues. Secondly, we're also aware that today it was supposed to be the sitting of the Independent Electoral Commission's court, or appear in court, in relation to the matter that has been brought to the attention of the courts contesting the 2024 provincial and national elections. Unfortunately, as I'm aware today, that the matter has been also be deferred, again postponed. It won't be sitting. However, we may need to now, because today we're supposed to meet with the IEC to get a detailed report on the provincial and national election. Given this court process, we ought to postpone the meeting, which will means now, Honorable Matonzi, we must formally interact with the IEC to give us 2 possible dates on the when can we have a full session with the IEC. I'm also fully aware that the period of June, July will be dealing with the budget debates, and we may need to see how we navigate this process of the IEC. It will be good that when we are going to debate the vote of the Home Affairs. At least we've met the IEC because we're going to deal with the budget moving forward and the allocation that have been presented. You'll note that also the minister in his budget presentation highlighted the budget allocation for IEC for the next 2026 local government election. So it's important that we meet with the Independent Electoral Commission to exhaust these matters. And I think members will agree that is important and overdue. We may also, in that process, have a guidance on how we'll interact with the IEC on the subject matter without engaging on areas that are before the courts. Can I now invite Honorable Mr. Matonsi on item number 2 and introduce an attender.
Only one apology, that of Ms. Mutambi. That's all from me, Chair.
Okay. Thanks very much. All apologies noted. Honorable Sitleng Gubani is also attending Joint Select Committee on Education, Higher Education and Basic, and the Select Committee. He has joined, however, he's in physical, and there will be, and he has put that apology to not to participate because they'll be physical and participating on another committee. I just wanted to put that apology so that it's noted. Members, we post last committee meeting because of the 2 or 3 issues that the committee needed to proceed and process. And the first matter is also on the issues that the Parliamentary Legal Services have responded to the portfolio committee, and also the the head office of Home Affairs has also responded to these issues. It's also reside on the implementation of the interest of justice criteria, which we have labored in terms of the conversation, whether it must be on the bill or it must be grounded in the regulations. And there were arguments that were forwarded by the legal services in relation to the strength of grounding them in the minister being powered to present them in the regulation, because it is within the constitution and also it is a legal framework that they will enforce for implementation in relation to section 7. And in our understanding, that is the only area that it need to be considered. Thirdly, there was an argument or submission that we may need to consider to ground it in the standard operating procedure. However, there were issues, concerns that were raised that is the standard operating procedure is an internal document, operational document, but also it's not accessible. And I think there were views that were expressed that is not able to be accessed because the standard operation procedure. We then ask the legal team or Department of Home Affairs to demonstrate in relation to these submissions that have been made to the Portfolio Committee on the standard operation procedure in relation to the issues that were raised to the committee. Because one of the areas that have been advanced was that members of the public are unable to comment on the standard operation procedure in relation to its implementation, but the views that were carried by the team suggest that I think they will demonstrate it when we invite them. I can confirm that I did further solicited understanding through Advocate Malekate. I had a one-on-one with him, and also I had a one-on-one with Daksha.
Hello? Oh, we are frustrated. Ngiphi ikhophi la ngaphandle.
Hello? Hello? Brother Ramajit? So we then and that was to assist the chair to better formulate understanding around these two subject matter. On the issue of the that has to do with the children, where also there's a principal agreement which we may need to bring to the attention of the committee, that we may need to consider to defer it to the process that is incoming in relation to the white paper. In other words, that it is not a subject matter that was brought in by or within the framework of the judgment, and this is the matter that the committee may need to approve, that we can defer it to the white paper that is coming. In relation to the Section 35, I think there's a understanding from both the Home Affairs and the Portfolio Committee to affirm the submission has been made by the Department of Home Affairs. So the critical matter is only one matter, that, and I think when Home Affairs respond, they will deal with it, and then the legal service and members contribute to that. I just want to lay the framework on what it has been our understanding and what we may need to consider in relation to what the constitutional, the court judgment has directed Parliament or Department of Home Affairs to correct the anomaly that was found to be inconsistent with the Constitution. Can I invite now the Director General, if he's in the meeting, just on the two issues, on all the issues, if they are comfortable on the approach, and then but also to demonstrate the standard departmental standard operation procedure. I'm not sure, firstly, Mr. Salmon, if that is a framework that we ought to invite these members.
Agreed, Chairperson.
All right, thank you. Can you proceed, the DG or Advocate Malekate? Mr. Martins, so DG is not in the meeting. I assume you indicate that it's in the meeting.
Chair, they are both in the meeting.
Okay.
Good morning, Chair.
Yeah, I think this one is not DG's voice. I can.
Sorry,
Morning.
sorry, Chair, for interrupting. It's Dion Erasmus speaking. DG is just in a JCPS cluster meeting, and he indicated that I must just indicate that, but that Mr. or Advocate Moses Malekate will proceed with the presentation.
Okay, okay. All right,
Thanks,
thank
Chair.
you. Thank you. Advocate Malekate.
Good morning, Chair, and good morning to members of the Portfolio Committee. Chair, just allow me to introduce Advocate Dion Erasmus, who just spoke now, and I was hoping that DG would come through and formally introduce the Advocate Dion Erasmus. He is the Chief Director, has just been appointed and came assumed duty from Monday last week as the Chief Director for Legal Services. So I am then going to be from our side, we're reporting directly to Advocate Erasmus. Just thought maybe that the chair as well as the committee should not be surprised that he came through. Chair, on the matter, we first want to indicate that, of course, once the Portfolio Committee makes the decision on the criterion, that the department is indeed amenable to the decisions of the Portfolio Committee. But safe to indicate that it may be very important for the Portfolio Committee to take into consideration that the sequencing of events when we apply Section 34 And we wanted to place before the committee that the committee should remember that although Section 34 you would say it's placed first in the legislation, but when immigration officers execute their functions as it relates to enforcement of law, as it relates to illegalities, then Section 41 of the Immigration Act is the first instance where the immigration officer will then make the determination whether or not it will be in the interest of justice to release such a person. So if we were to have regard to Section 41 of the Immigration Act, it empowers an immigration officer or a member of the South African Police Services or a member of any other law enforcement agency to, once they come into contact with any person, to then stop the person and request that person to identify themselves. At that point in time, the immigration officer or a member of the South African Police Service is then empowered to probe on whether or not such an individual is legal or illegal in the Republic. And in fact, there is an interview that the immigration officer will then need to take and take every other information that the person will then present to him. Secondly, Chair, the immigration officer is also obligated to assist an illegal foreigner to identify himself or herself. And at that stage, Chair, we want to submit that is at the stage where an immigration officer would then make a determination whether or not it will be in the interest of justice to either detain the person or to release the person. And if that it is indeed the case, at that point in time, when you come back to the judgment, in the ex parte judgment, you would see that under paragraphs 47 up to 42, indeed, the Constitutional Court does come back and say, when we look at Section 35, 1F of the Constitution, that any person who is detained may be released if the interest of justice so permits. And the Constitution does not go further to indicate or tabulate what would then be the meaning of the interest of justice. And if we come back to the paragraphs of the judgment, indeed, the Constitutional Court does indicate that the interest of justice or an immigration officer must release a person if the interest of justice so permits. The Constitutional Court further indicate that although the criterion is understood within those who would have studied law, and that it may be difficult for those who have not studied law, the Concord then indicate that there has to be guidance provided to immigration officer as to how they would then need to implement that. But the Concord does not go further to indicate the factors or the circumstances that an immigration officer would need to take into consideration, save to indicate that there has to be guidance. And they don't go further to indicate what then should be in that guidance. Chair, we also want to just to touch base that if the committee does decide that the interest of justice criterion must be included in the regulations, and we then go as the Parliamentary Legal Services advises that we need to then include a new provision under Section 7 that would then deal with that. We just want to submit that the committee would recall that when such a determination is made, an immigration officer would be looking at the circumstances of the individual before him, but as well as the evidence that would have been produced by the individual to show cause that he should be released and then the immigration officer, if he so determines that the interest of justice permits for such a release, he would then set the conditions. But the key important issue is that would be guided by the evidence that has been produced, but also the circumstances of the individual. So if we were to place the criterion and tabulate the factors that must be taken into account, that in itself means that the regulations will then provide some form of a closed list within which the immigration officer would need to take into account, and that may impact on the discretionary powers that are then supposed to be granted to an immigration officer. Chair, you would recall that the key factor is that the detention should be used as a last resort. But the preferable in our law, the preferable route to take is that the person should not be detained unless if there are reasons that allows that. So if we provide that closed list, then it means the immigration officer would then be obligated to follow the factors that have been tabulated in the regulation, and it may impact on that discretion. Yes, the other issue that we want to place before the committee is that if the factors are tabulated in the regulations, the members of the committee would recall that in the judgment itself, it then indicates that once a person is brought before court within the 48 hours, the presiding officer or the magistrate would then need to determine, in determining whether the lawfulness of the detention, the magistrate is also empowered with the power to determine whether or not the interest of justice permits a release, or if it doesn't, that it will then order that the lawfulness of the detention is indeed in line with the law, and that the particular individual should then be detained as such. So if we were to place that in the regulation, we may need to find a way to ensure that we do not go against what Section 165(2) of the Constitution indicates. So when we have regard to that section, it does indicate that the courts in our jurisprudence are independent and subject to the Constitution and the law, which they must apply in an impartial manner without fear, favor, or prejudice. So if we were to provide that closed list, it may very well be argued that when looking or determining whether the interest of justice permits, then it would indicate that the magistrate or the presiding officer confronted with this, they would then need to also abide or look at the factors that have been mentioned in the regulation and proceed accordingly, and that may impact on the element of impartiality on the magistrate. The last point that we just wanted to say is that when regard is had to the Eastern Cape High Court in Mthatha on the 24th of November 2023, in the DSK matter versus the Minister of Home Affairs, when we look at that case, we then would see that the court in that judgment does remind itself and remind ourselves that indeed in sequencing, Section 41 becomes key before 34, because 34 is only empowering or creating a criterion under which a person should be detained, and as well as the standards of detention. but the section 41 in the sequencing of event is key, and that is when the immigration officer will then determine whether or not it will be in the interest of justice to either release the person or to detain. And if the immigration officer then decides to release the person, of course, he will then set the particular conditions that he has. But in the main and in conclusion, Chair, and having made the submissions, I just need to reiterate that the department is, of course, amenable and to the decisions of the committee, and we would then be able to, once the decision is taken by the committee, will then between ourselves, the Office of the Chief State Law Advisor, as well as the Parliamentary Legal Services, then proceed to draft the A list to give effect to the decisions of the committee. Thank you, Chair.
Thank you, Honorable Advocate Malikat. There was an issue of access to the standard operation procedure, which I think was raised in the committee meeting. If you can just get to the extent, is there any legal obstacle that contributes to the non-access of the standard operation procedure? I understand an internal operation document that in terms of the views expressed, it does not have a legal standing. I just wanted to raise it so that you explore on that area.
No, thank you, Chair, and members of the committee. Indeed, we can confirm that a standard operating procedure seeks to provide guidance on operationally on how officials of the department, and in this case, immigration officers, would need to execute their functions. And indeed, when we're looking at the legislation, the standard operating procedures cannot go against what the piece of legislation and legislation in this case, I'm talking to the Act as well as the regulations. They cannot go against that. And they just seek to guide officials of the department on how best to execute their functions. Generally, those are internal documents, but there is no legal impediment or legal obstacles where the department has taken an executive decision on making that accessible and readily available, either on request or simply by publishing that for use or knowledge or for people outside of the department. So in the event that the committee then decides that, because we have been submitting that in this instance, the standard operating procedure, given that we just need to provide guidance to the immigration officer or officers on how to implement the interest of justice criteria, we have been submitting that the instrument to be used, or the best instrument, would be the standard operating procedure. And in this case, there would be no legal impediment in publishing the standard operating procedure, so that it is well known outside of the department also. We have not found in our research that there would be anything that would indicate that the department would have done something that is in contravention of the law. Thank you, Chair.
Okay, thanks, Advocate Malikate, and congratulations, Advocate Erasmus, for your new responsibilities in the legal service unit. Members, I will request you to, if you have issues to raise with the department before I invite parliamentary legal services to also comment if there's an issue you want to raise with the Department of Home Affairs. Honorable Ross?
Yeah, thank you, Chair. And thanks to Advocate Malakati for the further inputs. Chair, I think what has been mentioned here largely talks about the discretion of immigration officers and the discretion of judges and the, almost sort of saying that if you had to put the interest of justice criteria in regulations, it would interfere with this discretion. So, Chair, the Constitutional Court has guided us here in the Dawood versus Minister of Home Affairs matter. And there, the Constitutional Court established that where an official exercises discretion that can limit fundamental rights, then such discretion must be guided in a manner that is consistent with the Constitution, particularly the rights to dignity and just administrative action. So the court criticized unguided discretion and emphasized the need for legislative or regulatory frameworks to direct such decisions. So SOPs are inadequate in this case because what they do is they guide day-to-day administrative actions, but they do not carry any force of law. And they're also not subject to any public consultation or parliamentary oversight. And so what they, it's an unsuitable element to take something like that and embed constitutional discretion. We're talking about discretion here. It is matters specifically related to constitutional rights. So regulations are appropriate because they carry legal authority and are binding. I think the issue raised, first of all, is the discretion of immigration officers. So Section 41, yes, it talks about the determination of the status. Are you here legally or illegally, etc., and should you be detained? So there's no reason why any SOPs cannot refer to the regulations, if need be. But they're more for procedural things. They are not to determine the balancing of human rights, etc. So they don't interfere with the discretion of immigration officers because your SOPs can simply be adjusted for the regulations or take them into account. They would take them into account. Then the discretion of judges, Section 165(2), there wouldn't be any problem with interfering with their discretion because you already have these kind of rules in the Criminal Procedure Act. And there in that act, it specifically lists the interest of justice criteria. So judges referring to legislation which guides them on the interest of justice criteria it's a practice that already exists in criminal law. So there's never been a question of whether it's interfering with their discretion. And again, I'm going back to the Dawood case where it talks against it specifically talks against the use of discretion without being guided by constitutional rights. So, Chairperson, I truly believe I believe we should move with the option 1.2 in terms of having these interests of justice criteria in the regulations. What that does is it allows the department to formulate them, and it allows it to be in the public under some sort of oversight. And it also allows from time to time for practical reasons or where you're implementing this to come and say that, you need to make a change or two. So it gives the department some sort of a leeway to do that. And then secondly, even if you had to change the criteria from the minister may issue regulations to the minister must, that would only apply to Section 7. So it would be a very limited requirement to put these regulations together, Chair. And once they are there, the standard operating procedures speak to those regulations. And it provides guidance for the immigration officer. It also provides guidance for the judges, but also the counsel, the defense counsel, to understand what those rights are. So Chairperson, I think it would be in everybody's best interest to go with that option, Chair. Thank you.
Okay, let me request the legal to come in, then so that I allow members to join, and I'll then get Advocate Malekate and the DG to also respond on the comments of all members once they've dealt with it. And I want members also to indicate that as on the two other issues, including the last point of the children, we have deferred to, we'll deal with it on the white, when we deal with the white paper. So that when we close all the items, we're clearer on the proposal that we've established earlier on. Legal.
Good morning, Chairperson and honorable members. This is Daksha here. I also have Ms. Clara Williams in the office with me. Chairperson, Dr. Roos pretty much covered what we would have said in a response, but I just want to hone in on three particular issues. The first is that Advocate Malekate spoke about if one were to leave this to the regs, it would be a closed list. Chair, we tend to disagree with that because there's a way of crafting a list by making sure it's open-end, or not, it would be an open-ended list, which means you could include other factors if and when they arise by including in the drafting the word include. Also, if there are other factors that an immigration officer in the future must consider in respect of this, the minister could always then amend those regulations to include those extra factors. The other issue is that here we are giving the Minister of Home Affairs the power to make these regulations, and he can then only make these regulations in respect of officials within his department. So these regulations in respect of the interest of justice criteria will only be in respect of the immigration officers, Chair. And then I was looking at section 34 again as it is in the bill. I mean, if you look at subsection 1A, paragraph A, the interest of justice standard must be applied by an immigration officer in respect of section 34. So, I mean, I understand that Advocate Malekate was referring to section 41 of the Act, but my understanding of that is only in respect of identifying the person's status. And once it's been revealed that the person is an illegal foreigner, then section 34 applies in respect of considering whether the detention is in the interest of justice. I'm just going to hand over to Ms. Williams. She has one point to make. Thank you, Chair.
Thank you so much, Chair. Chair, we also agree with Dr. Roos relating to the instrument that should be used. So we've indicated in the past that it is our view that the criteria should be set out in either the Act or in the regulations, because we also agree that the SOPs do not have any legal standing and it is not accessible to the public. It is an internal document that can be amended without notice to the public as well. So we do agree that that is our interpretation of the Darwood judgment, that guidance should be provided in legislation, whether that is then in the Act or in the regulations. Thank you, Chair.
Thank you, members. The Chief State Law Advisor, is there another matter you want to raise before I invite members again?
Good morning, Honorable Chairperson, Honorable members. Thank you, Chairperson, for allowing us to have some slight input into what has been presented. Chairperson, through you, just with regard to the explanation that has been given by the department, we understand what has been said to mean that there is an interview that is done in terms of Section 41. And as Ms. Kassan has pointed out, that is in respect of identifying the person to determine if they are, in fact, a citizen of the country or if they are a foreigner, and then the next inquiry is to determine whether they are illegally in the country, and an interview is being done at that stage. And depending on the outcome of that, the person would then be either declared, well, if the person is declared as illegal in terms of Section 32, then the next process is Section 34, which is what we are currently looking at in terms of the bill. Chairperson, through you, if it's possible for the department to explain, because we've also tried to follow the process as has been explained by the department, and we've also looked at the regulations. We note that there are regulations already in place in respect of Section 41 and what needs to be considered by an immigration officer in determining the identity and verifying the status of a person. And it's listed in Regulation 37, that's of the 2018 regulations. And it talks about the factors that must be considered, and it includes access to relevant documents that must be available, the contacting of relatives or persons who could verify the identity and status of a person, departmental records, and our understanding of that is to check if a person has, in fact, possibly, maybe, for example, applied for asylum or something similar. And the other criteria is to provide the necessary means for a person to obtain documents. So, Chairperson, it does appear that there is an interview that is already done in the Section 41 procedure. And we note that in Section 34, there's also mention being made of an interview as well. And I think the clarification that we are trying to establish based on what the department has presented is there a link between the interview and 41? Is the same criteria which is already prescribed in Regulation 37 in terms of identification, are these same factors the factors that will possibly be carried over to the interview in 34, which already then stipulates that there is a criteria that has already been prescribed, or is it a different criteria which in that event, as has been discussed, would need to be incorporated into the regulations? So through you, Chair, I hope that explains the process or the possible link that we have tried to find in the department's explanation. And we do hope that may assist us as well as the Chair and the honorable members to understand the link that they are trying to provide in respect of 41, 32, and 34. Thank you, Chair.
So yes, yeah. I think I know it's not your resolve position. Is that it then will suggest that we must place the interest of justice in the regulations or on this SOP?
Chairperson, we're not giving any we're not stating where it should be, but I think we're just trying to understand if the criteria in Regulation 37 in respect of identification, that's already a criteria that is prescribed. And it appears that this could be the same criteria that's possibly considered in 34. But we were just requiring the department to clarify if that is the case. If it is not the case, then if it is the committee's finding that it should be included in regulations, then we think that is a possible option, depending on the instructions of the committee in this regard.
Okay, thank you. Noted. The DG?
No, good morning, Chair, and good morning, honorable members. Apologies, I'm presenting at the JCPS as well, so apologies for that. I think having consulted the team and the minister on this matter, let's start with the interest of justice. Advocate Malakate will deal with the other issues that Daksha is raising. I think we can leave with the suggestions contained in 112, which require that the provisions be recorded in the regulations. If there's a view, Chair, that the provisions in the SOP will be inadequate and not practical as suggested by some, we will be comfortable as a department with that suggestion to include this or record in the regulations. That will be the view of the department after consultations with the minister. Thank you, Chair.
You have went to Oronia again, Mr. DG. Yeah, you're back now.
Can you hear me, Chair?
Yeah, proceed, DG.
No, I was saying the stance by the department after consultation with the minister is that the department will be comfortable with the suggestions as contained in 112, which require that these provisions are recorded in the regulations, which are normally gazetted by the minister in the government gazette, and therefore have a much more legal standing. Given the fact that I think the indication is that the SOPs it's an internal matter or internal document, and therefore might not be sufficiently addressing the issues that were raised by the Concord. Thank you, Chair.
Okay, thank you very much, DG. I think that clarify the issues that we've been raising. I'm not sure if Advocate Malekate want to comment on other issues that members have raised. Not members, I mean the colleagues. Yeah.
No, I think, Chair, given what the Director General has just indicated, from my side, I think I'm fine.
Okay. Members, I think there's now clarity on the process that we need to engage on, and the proposal that after the consultation by the Director General and Advocate Malekate, and also the Parliamentary Legal Services, and also the inputs that has been carried. Can I get a sense from members on the views that have been now being solicited by how do we move forward? I don't want to place it outside honorable members to deal with this matter. Honorable Mdolo, I can see your hand. Honorable Ngobeni, and then Honorable Ruas. Honorable Mdolo. And Honorable Modise.
Thank you, Chair. Greeting to committee members and all members. NC believes we should only fix what the court ordered. Chair, the committee should amend just those parts of the law required by the Constitutional Court judgment, rather than rewrite the entire act. With the respect to the interest of the justice, the decision should be set out in simple, internally guide as SOP for a legal officers. This guide will explain when and how an undocumented immigrant may be released on the grounds of interest of justice, giving officers clear but flexible instructions. Chair, as for rights on arrest, the Constitution already guarantees them in Section 35, subsection 2. Rather than restarting these rights in the bill, every detainee should receive a standalone notice of rights form similar to the one used by the police to keep the bill concise while ensuring that everyone knows their right. The last one, Chair. Provision relating the children were not addressed in the Constitutional Court judgment. These should be dealt with later in the forthcoming white paper on the citizenship, immigration, and the refugee protection, where there is a room for a more comprehensive policy discussion. I thank you, Chair.
Thank you, Honorable Mdolo. I think the two issues that Honorable Mdolo is bringing is to affirm what we have proposed in relation to deferring the matter of the children to white paper, and also affirming what the proposal in terms of languages to be carried. And now we'll deal with the issues that have been raised. Honorable Disemza, Honorable Lerato Ngobeni, Honorable Andres Ross. Honorable Disemza.
Thank you very much, Chair. I think the member has already dealt with some of the issues. I think I would make a comment on what the DG would have made comment on with regards to regulations. I think if that's the resolve and a direction that the committee should look into, then say it should be supported. So I support the views on taking the directions of taking the interest of justice on regulations. Thank you, Chair.
Thank you, Honorable Disimse. Honorable Lerato Ngobeni.
Thank you, Chair. Good morning, colleagues. No, I think it was just handled just now. I wasn't at the previous meeting. I wanted just clarity on the dealing of children because that wasn't handled in this white paper. So I wanted just clarity on how we're moving forward in that regard. Thanks.
Thank you, Honorable Lerato Ngobeni. I think that clarity was offered by the previous speaker. Thanks very much. Honorable Ruas.
Yeah, thank you, Chair. So I'll just go item 1, 2, 3. So item 1, we must just bear in mind that we are, this bill is in response to the Lawyers for Human Rights versus Minister of Home Affairs judgment. And in that judgment, the court criticized the absence of an interest of justice criterion in the detention process, and indicated that such criteria should be applied to ensure that detentions are justified and proportionate. And certainly, I think there's been plenty of argument that that would be best put in the regulations, Chair. Then the second matter is the matter of the Section 35(2) rights. I think once again, the right to be told of the reasons for being detained, to consult with a legal practitioner, and to have a legal practitioner assigned by the state. We agree with that. The other question was about whether the representations by the detained forum may be oral or written, and we say both. And then regarding the language in which the detainee should be informed, should the bill, as per public submissions, delete the caveat where possible, practicable and available? We say no, Chairperson. And again, I gave the case in the last meeting where, so this is to make it just practical. But bearing in mind that there is a court judgment as well. If the department had to say that this is impractical, they would have to prove that in a court of law. So we are covered in that regard, Chair. Then on item 3, in terms of children, I think we'd indicated in the last meeting that in the Refugees Act, there were specific references to children and children's rights. Chair, we received a lot of input in this regard that these rights are already covered in other legislation, Chair. So it can be acceptable to leave it to that. But again, as we've committed before, to engage with the Department of Health or the Department of Social Development as part of the white paper process to look at the treatment of children as a whole, and ensure that is covered in any future legislation more explicitly. But for this one, Chair, it is fine if it is, if practitioners are able to refer to the Constitution, to the Children's Act, etc., for how children are protected in these situations. And again, it was indicated to us that there are processes in place to deal with children in these situations, and so we can be satisfied that those processes are in place, Chair. Thank you.
No, thanks, Honorable Ross. I think what has already been placed on record in terms of the two issues that we have agreed, including the last point, I think Honorable Mtolo has articulated it in detail. Now that we have had consensus on all the issues, parliamentary legal services, what would then be the process to move to establish the ALIs? I understand that we must adopt a framework, and then we should also establish the time frame on how we're going to interact with the process. Daksha?
Chairperson, if I could maybe just use this opportunity to just recap on the decisions, because that would then form our instructions on to ourselves and to Office of the Chief State Law Advisor to develop the A list. So if I can just confirm, and if I'm wrong, if that could be pointed out, that in
Can I suggest differently, Daksha, so that we don't have difficulties, and I think members will assist me,
yeah.
that on the decisions that have been carried, is it possible to draft notes? Otherwise, we'll then move back to discuss, unless it will waste time for you to come back to the committee. But if you'll be comfortable, the members are comfortable on agreed position, you will proceed. Just proceed, then members will guide from there. But I'm trying to caution the difficulties that may arise. Just proceed, and members will guide after that. Yeah.
Chair, from what I heard, I think the majority of the members who expressed a view agree that the criteria for the interest of justice should be placed in the regulations. On item 2.1, there were two views here, but I'm hearing the majority saying, and correct me if I'm wrong, that the rights contained in section 35(2)(a) in respect of consulting a legal practitioner and getting legal aid, as well as representations being oral or written, should be provided for in the bill. In respect of 2.3, I'm hearing the view to be that the words "where possible, practical and available" should not be removed, and it should remain in the bill. And as far as children is concerned, that item be deferred to the white paper. Thank you, Chair.
Thank you very much. I think that is a framework in which this meeting has arrived at. Is there a matter, members, you think is not captured well? Okay, carried. Then let's establish a process.
Chairperson, in that respect, we will now, together with the Office of the Chief State Law Advisor, prepare these amendments. I'm not sure if there's a meeting next week, but if there is, we could have it ready by next week. But I can just check, if you can just quickly check with Ms. Govender if that would be possible, and we could table it in next week's meeting. There's just one more thing, because we would be amending section 7 of the Act, which is not in the bill. Eddie would just need to draft a request for permission to amend that section in terms of NA Rule 286(4)(c), because we just need to get permission because we are amending another section of the Act that's not in the bill. And Eddie can speak about how he would go about doing that request, which needs to be tabled in the House. Thank you, Chair.
Mr. Matonzi?
Hi, Chair. Yes, I'll be drafting remember last time we did write a report to the National Assembly to request the National Assembly to allow the committee to amend a section which was not there in the bill. So I'll be drafting that notice, Chairperson, and then I'll share it with Legal Service and the Content Advisor, so that the committee is able to consider it and adopt it and send it to the National Assembly, Chair.
In our next committee meeting?
Yeah.
Okay. All right. Chief State Law Advisor, comment?
Chairperson, we should be ready to present the A-list in collaboration with the Parliamentary Legal Services at the next meeting.
Okay, thanks very much, colleagues, with that framework, and thanks, honorable members, for having grappled with this question. And I must thank Advocate Malekate for having demonstrated good work in terms of the contributions and assisting the committee in this matter, but also the Director General through the consultation, because the art of arriving at the decision must be based always on extensive consultation. And I think, Advocate Malakat, you have demonstrated that you must affirm your contribution and also your willingness to serve in the department. I've also identified that part when we deal with the marriage bill. I must say it here now that you have a new DG or a new chief director on the good work that you have demonstrated with the committee, and also the team led by the collective of Daksha and Williams and Cavender, that we have arrived at this period of a decision. So we'll allow that process to move, and we'll then bring to the attention of the committee in our next committee meeting. We'll release you, colleagues, and thanks very much. We'll then leave with the members of the committee to deal with the minutes that must be adopted. I think there are a few minutes. It's only for committee members, Ms. Cavender, Daksha, and the team, and Williams, and the DG and the team of Home Affairs, Advocate Malikat, you are released. Thanks very much. Thank you very much, Mr. Matonsi. Mr. Matonsi is
I was muted, Chair. I couldn't see that I was muted, Chair. Yes, we do, I think, 4 sets of minutes from last year, which was from the 5th of November, where the committee received a briefing from the Minister and Government Printing Works on the Minister Review Panel recommendation on the data loss. And then we also received a briefing by the Minister on the one-stop border post on the issue of correcting the continual court judgment on the Refugee Act, and then also legal service court judgment on the section on the immigration on section 10.6, 10.11, 18.2 on the Immigration Act. That's the one that we received a briefing previously just now, and then we also adopted minutes. So these are the minutes, Chairperson, and these are the people that were in the meeting.
Thanks very much, members. These are the minutes of the 5th of November. Any other matter I want to raise before we consider adoption or rejection? Honorable Ross?
Chair, if I may, the surname of the minister is spelled as Schreiber on all the minutes. So it should be Schreiber. If I may just give that input now, and then it counts across all of them. Otherwise, I will have to say the same thing across all the minutes, with your indulgence, Chair.
Not that Honorable Ross.
Okay, thank you very much. I think Honorable Ross in all the minutes is corrected the surname. I've realized that you have not corrected my surname, Honorable Ross, in all the minutes, but I've noted it. Any other matter? Can I invite members for the adoption of the minutes of the 5th November?
Chair, I move for adoption.
Thanks, Honorable Ross. Seconder?
Second.
Thank you. Minutes are carried. Thank you. Any
Chairperson, I didn't get the seconder, Chair. The name of the seconder.
Ngobeni.
Okay, thanks.
Yeah.
Okay.
Thank you. How many minutes, Mr. Matonsi? Let me just establish first.
They are up to last week. There are 16.
There are 16 minutes.
Yeah.
Okay.
Up to last week. Up to the previous.
Okay. Let's adopt 6 minutes. The rest will adopt as in the next committee meeting.
Oh, okay, Chair.
Can you move the second one?
The second one is the 26th of November. where the BMA briefed the committee on their readiness for the festive season, and also the update on the immigration amendment bill and political party funding submissions.
Thank you, members. These are the minutes.
Move for the adoption, sir.
Second, Chair.
Move and seconded. Moved by Honorable Machi, seconded by Honorable Mtolo.
Okay.
Can you move with those amendments raised by Honorable Ross? Of the
Yes, I
Senate?
will.
Can you move the third one?
Third one. Chairperson, this is the 3rd of December last year, where we had the public hearings on the party funding. That was it, party funding, the public hearing on party funding limits and threshold.
Okay. Members, these are the minutes that reflect our conversation.
I
Will
move
those-
for the adoption, sir. Seconded by Machi.
Move for the adoption on December with the amendment of Honorable Ross, seconded by Honorable Machi. Can you move for the fourth minutes?
Chair, I'm just moving over to number 4. Chair, this was a short meeting after the 3rd of December. We also met on the 4th of December just to request that they should be further studied by the PBO office and also the National Treasury on the political party funding.
Thanks, members. Can we consider for adoption?
Move for the adoption.
Honorable Ngoyi.
Second, sir.
Thanks, Honorable Disemza.
Chair, if I may, just for purposes of order, I think in line 3 at the very top, there's too much spacing. If they can just fix that, then it's fine. It says "and deliberations." So, yeah, you can move back, Mr. Matonsi. Move back all the way up. Yeah, so line 3, committee deliberations on funding donations limit and disclosure. You need to cut that spacing.
Okay,
Thank you.
noted. It has been carried. We're moving to the 5th minutes.
For February this year, where the PBO office was briefing the committee on their study, the possible amounts for the donation and threshold, and then the Parliament Legal Service also briefed the committee on all legal matters that are to the committee. Then also I briefed the committee on the first term program and public hearings that were going to take place in KZN and Eastern Cape.
Okay, members. Carried. Can I invite hands for seconder?
Seconded, Chair.
Second.
Any seconder? Move of adoption and seconder?
Move,
I move
Chair.
for the adoption, Chair.
I second.
There's a consensus. Move for the adoption. Honorable Mr. Matonsi and seconder carried. Can now move to the last minutes.
The last one was the public hearings. A briefing by the content advisor on the summary of written submission on the immigration amendment bill. That's the bill that we're dealing with today. And then he briefed us that day, and then also the organization below made oral submission. Yeah. It was a public hearing on the immigration bill, 11 February.
It was on immigration. Okay.
On the immigration bill.
Okay. Thanks, members. This was a public hearing. Can I invite hands to move for adoption?
I move, Chair.
Seconder?
Second, Chair.
Thank you very much. Carried, Mr. Matonzi. Thanks, honorable members, for carrying all the minutes that reflect our collective participation. And note that the 16 minutes will defer the other. Next week we'll deal with the other 6, and then the other week we'll deal with the 6 so that we complete all the minutes. Is there any other matter members want to raise? Okay. Mr. Matonzi, next. Okay. Proceed.
No, I just wanted to let members that in the meeting last week, it was agreed that no, I should apply for the committee to be excused for the sitting in the afternoon on Tuesday, the 12th. So I made that application, and then it was approved. So I've sent a message on the WhatsApp group that members should be in contact with Mr. Arens in terms of the time of when they are supposed to be flying over to Joburg, because from Joburg we have to drive to Rustenburg. So I'll request that all members who have not yet indicated to Mr. Thurston from which airport they will be flying to and what time they should indicate that, so that now all of us will meet in Johannesburg, and then we all drive together to Rustenburg. Okay, that's all. And then I'll give next week on Tuesday, I'll also give an update to the committee on the preparation.
Okay. What are we dealing with next week?
I don't have my program here at the moment, Chair.
Okay.
I'm not sure if I'll let you know.
Yeah, we'll request you to write a letter to the IEC to remember today we're supposed to meet them. To write a letter to IEC to give us a date, in fact, request them and give them 2 possible dates on Tuesday. And secondly, apply to chair of chairs that the date that they're going to have, at least it must be, members must be excused from plenary to focus on this area if there's no critical matter. I know that the report of the IEC would be a subject of interest to all of us, so that we have enough time to engage with the IEC, and also request them, if possible, indication of the issues that will be arising as we proceed for local government elections in 2026 or early 2027. But I wanted to put it on record that we may need to prepare for that session. I think that'd be fine.
Yeah, Chair. I did speak to the CEO, I think last week, regarding the meeting that we're supposed to have today. And then, Chair, if you recall, there was also an email that they wrote that I forwarded over to you regarding today's court matter, that you said, no, it has been deferred to another date. But also in that email, they indicated a diary for the commissioners that they are going to be busy, I think, until towards the end of June, which is from the 23rd onwards. So we might have to look from the 23rd of June up to July for the engagement with the IEC. But I will write the letter to the IEC anyway.
No, the IEC can dictate when. The only area we have been agreeable with the speaker is on the issue of the court, that they are engaged in the court. And we've since clarified that with the Speaker in terms of the engagement. So they can't tell us when they are free to interact with Parliament. You must write that letter and identify a date where they must come to Parliament. We're not agreeable to that reasoning. That commissioners will be busy. We must work on their terms of right. We're only agreeable on the agreement of the Speaker in relation to the court, and I think they've came to terms that they must appear before. We've postponed this meeting today because the court was sitting. That was the reason, and we've respected that issue. These other reasons are seek to undermine our work. I see your hand, Adams and Honorable Mdisemza.
Thank you, Chair. No, I just wanted to clarify that the items on next week's agenda are the further processing of the immigration bill today, so we can look at the A list. And then secondly, the motion of desirability for the one-stop border post, just because you asked. Thank you, Chair.
Okay, thanks. Noted. Honorable Mdisemza.
Thank you very much, Chair. I just needed clarity on the upcoming public hearings in Northwest. Mr. Matonsi would have made mention, even on the group, that on the 10th we must be excused. But also the communication is that we'll be departing on the 12th. So I want to understand which dates, when are we departing, and if we are departing on the 12th, why are we being excused to attend parliamentary commitments on the 10th, but we are leaving on the 12th to the 16th of June. I just needed clarity on that. Thank you.
Mr. Matonsi.
Yes, I think I did last week brief the committee that initially we applied to leave after the sitting on the 12th, but we were going to sleep in Johannesburg and wake up early in the morning to drive from Johannesburg to Rustenburg. Then the committee decided last week that no, there would be too much driving because we have to drive about 2 hours from Johannesburg to Rustenburg and then have public hearing on the 13th. And then from there, we don't have to sleep in Rustenburg. We have to drive another 2 hours to Mahikeng. So that was the reason why the committee last week decided that no, we should apply to be excused for the sitting on Thursday next week so that we can leave early and then we go straight to Rustenburg. That was the reason.
Through you, Chair, Mr. Matonsi, are we being excused from the sitting on Thursday or the 10th? I heard you speaking about the 10th. That's where I needed clarity.
Oh, no, I mentioned that the 12th, not the 10th. The 12th, not the
12th.
10th. Yeah.
Okay. No, thank you. Thank you.
Is there any other matter members want to raise for clarity or comment? Okay. Thanks, members. If there's no any other clarity, thanks, members, for this meeting, attending your meeting, and also the contribution and the decisions that we've carried. And Mr. Matonsi, we're clearer on how you must interface with the Independent Electoral Commission. This meeting stands adjourned.
Thank you, Chair.